for those who weren't on the, and I hope everyone's okay, we are recording this meeting. As background to everyone who was not on the Thursday meeting last week, we did discuss the fact that SJRES 1 is being pushed for a vote by Senator Cardin's office in this kind of session. So hopefully in May. There had been thoughts around Mother's Day, which is this Sunday. That's not going to happen, but they are pushing for a vote to get the senators on the record. We know that we will have a majority vote. Senator Murkowski has committed to voting for what is actually JRES 17, and it is not actually SJRES 1. So it's a procedural move that's a little bit out of regular order, but she is committed to voting for this procedural move of bringing it straight to the floor without committee action. And it is something that, you know, we worked with Senator Cardin's office. They feel strongly that they've been working on this bill for a very long time, and, you know, we deserve to see where everyone stands. And additionally, we know that it could be used importantly in the upcoming election, which is incredibly important to us. And two, you know, because the only way to see this bill pass is either by getting 60 votes or by breaking the filibuster, which, you know, is something that the coalition has also taken as a standpoint of supporting, but that has not been easy with people like Senator Manchin and Sinema in the Senate. So we have sent a letter to Senator Schumer's office signed by 135 organizations encouraging and urging the Senate to bring HJRES 17 for a vote. So we are on record as a coalition as being supportive of this vote. And so I just want to, you know, lay that out, that it would be very difficult for us, you know, as the ERA coalition to kind of take back that. So we are publicly out there with petitions, with letters encouraging this vote. However, we are an umbrella organization of 260 organizations, and we know that on everything we discussed today, there are people who have different opinions and feelings and thoughts on it. So, you know, we wanted to make sure that we have the opportunity to open up that discussion. We are really excited to have some legal and constitutional scholars on to answer maybe some questions about what this means. But that is the background that I am setting. So please, you know where our background is. Now we want to hear from you. So if anyone wants to raise their hand to speak. Victoria Norse.
Hi, everyone. The only reason that I really should be on this call is I'm one of 2% of law professors who've ever worked in any legislature. So I'm going to talk about this. They're going to do this whether you want it or not, because they need it. Dobbs has now made women's equal rights a very, very important political issue, and it will energize the base. So that's the reality of what I think is going to go on in the Senate. I'll let Catherine and others talk about its impact on the litigation. You know, you have 51, and my question for, you know, is how to message it, really. You know, I hate it. I think I've tweeted about it. One of the things I would love is the press should stop talking about a filibuster as a procedural move. They should call it minority rule. And I think that if there is a vote, and I think there will be a vote, whether or not this coalition likes it or not, and it's because of the individual races, right? The message has to be, this is minority rule. You know, this is not, you know, the problem is it will be a cloture vote. And I've been through a few of those in my life. And, you know, people will take that as, you know, the one part of the press will read that as, oh, they voted against it. I think it is better in that posture if the messaging is correct, that they wouldn't let, the minority would not let people vote on this. That's what it really means, okay? Because cloture is to end debate. There is no way to end debate in the Senate, because like there is in the House. So I think it's going to happen. I think, you know, you really need to think about how you want to present the message, and you need to know something about the procedure to, and why that really is a minority position, to message what will happen when there are 51 votes. And I assume since there are 51 co-sponsors, I would like someone to explain to me, I don't know what Murkowski's position is on this other provision. I assume that they're not going through committee and they're just discharging it from the committee, but I need to know a little bit more about that.
Yes, so there are actually 52 co-sponsors. So Murkowski and Collins are both on the bill. Someone asked if Collins is going to vote on this procedural mover that's going around the committee process. So when HJ Res 17 came over from the House, they held it at the desk so that Leader Schumer could bring it straight to the floor, so that there are kind of two bites of the apple, I guess. One would be through this process, which would allow there to be a vote without actually killing the potential of the Senate bill moving forward, because it could go through committee process if that was necessary. We don't know about Collins only because we haven't received, you know, confirmation one way or the other. There's no reason to believe she wouldn't vote for it. We just don't know, you know, definitively, but Senator Cardin's office, who works closely with Senator Murkowski's office, did bring it to Murkowski's office to say, would you support us doing this? Would you vote for it? So that's why we have the definitive yes from Murkowski's office.
Okay.
Linda or Catherine, would you like to weigh in on this discussion? And the question that we have as we're working in the Senate is whether or not the ERA would go before the Women's Health Protective Act. We are actually in better shape numbers wise than them. Linda?
Could I jump in for just a second?
Yeah,
Would you mind?
right.
Because we've been working closely with Cardin's office on this as well. And I want to compliment, not in the sense of you look lovely, but add additional comments to Victoria's comments, although she does look lovely, by urging us quite a slight shift in the perspective. And this is what we've been working on with Cardin's office, and I'll have out in an op-ed in the next couple of days, is to see the cloture vote as a success, not to see it as an opportunity to shame those who voted in favor of the filibuster. And in that sense, we can say, look, we have a bipartisan majority that favors the final ratification of the ERA. This is the way that Article 5 of the Constitution works, is it's a hyper-democratic process, having to go through both Congress and then state legislatures. And the filibuster is the epitome of an anti-democratic measure. And what's also really important is that the vote on the deadline, there was a vote before it, and Ellie, I'm sure, remembers, having been there working so hard on it, that the vote on the deadline, there was a motion to require a supermajority, a filibuster number of senators to approve the deadline, and it was voted down. So there's a legislative history here of refusing to use the filibuster or a filibuster-like requirement of a supermajority to vote on the deadline. And so to vote for the lifting of the deadline should be done in the same way. So I think how we message this is 51, 52, we could even get another Republican after the outrage having related to this released draft opinion. 53 votes is a majority. And given that amending the Constitution is itself a political, not a legal process, this signals the political will of the people to finalize the ERA and then put pressure on Biden at that point to say, I recognize the ERA as now effective. Right? It gives him something new to say other than that I'm happy about the ERA in a general sort of way. So I think we could see that the not getting 60 votes is itself a victory, rather than yet another tragic loss that we use to shame those who are voting against us.
Linda, would you like to weigh in?
I think that's a really excellent point. And in fact, I think both Professor Franke and Professor Norris have really great points about the messaging. I've long thought that how we message this is incredibly important, because at this point, I don't think a message of they're all against it, they're all opposing us is the right way to go. I mean, what we're seeing right now is a real threat to civil rights down the road. We need to be very thoughtful about how we're messaging these things. I really love the idea of using of telling a narrative that the cloture vote, even though it's going to fail, is a victory because it reveals majority support. I think all of those are incredibly important points. And I think we have to be very clear and precise in our messaging for those reasons. It's really tempting to just try to light everybody on fire on this. It's really tempting. But I think it's really important that we don't do that at this political moment, because look, what we've learned this week is something we've all probably should have realized a long time ago, which is that we who are on the left and are interested in civil rights can no longer trust that the courts are going to be vindicating civil rights. We need to put our attention on elected officials. And I think good messaging on this issue is part of that. And we need to be sensitive to the pressures and the political needs of the elected officials and support the ones who are supporting civil rights, including and particularly sex equality.
Yeah, I see we
Thank
have
you.
some hands up, but I'm going to let you handle the hands.
Sure. I first want to go to Victoria Norso to kind of cap off the discussion of the lawyers, and then go to, we have Nicole, Ellie, and Donna.
I just want to say that something quickly, that I think Catherine's strategy is brilliant. I think that's absolutely the way to go. And the more people who can adopt that and get that into local papers, people misunderstand politics. The federal level is only about Washington, when in fact, there are still local papers, not many. But if people can get that word out there, that messaging, that would be helpful on the coalition. Two, does Schumer's office know, this is a question, does Schumer's office know about the precedent? Because that is very important. I'd forgotten that, Catherine. And that is so important that there is a precedent, because the Senate does operate by precedent. And is there a way that he could be persuaded to use that, not to end the filibuster, but to maybe frame the resolution in that way, so it wouldn't say anything about the filibuster generally, but it would have to do with this particular constitutional amendment?
That is, I will say that we've been working hard to get Senator Schumer's office, Leader Schumer's office has been very reticent about having an in-depth conversation about this moving forward, but that is something that we should definitely message to them. I know Ellie has been working and just racking her brain about how we can do exactly what you're saying. We've met with former parliamentarians, and one of the things that I thought was really interesting that the former parliamentarian said to us was that your opponents, we come to like a war, like they're fully armored and we come with a little knife. They are so good at understanding procedural maneuvers, and we have not been able to really do that as well, which is one of the reasons that we're in this position. So I think, again, just going back to Catherine, and then we will go to the rest of the conversation.
Just a couple of other quick points that, and I don't want to take up too much airtime here. One thing that I'm hesitating to argue, but we might need to, is that part of Alito's argument, and this was also Kavanaugh's big point during the oral argument in Dobbs, is that these issues should be states' rights issues. And they really lift up this idea of the states each having their own kind of rules on this. Well, if that's the case, then the states have ratified the ERA. Right? What was Virginia, Nevada, and Illinois doing when they were ratifying? It's an insult to those states. to say your votes didn't matter. So I think that we can boomerang some of that state rights stuff back in our direction, which, in general, I don't agree with it on the abortion level, but it's kind of the argument we're stuck with. The other one thing to think about also is of urging with Leader Schumer is to pair the ERA with this Roe vote. I think codifying Roe is a terrible idea. Roe is not a great decision to begin with. So, we have much better legislation pending in Congress that would exceed the protections of Roe. But whatever it is they end up doing around that, putting these two together, I think would be really important. Part of what we need to be messaging now is that the ERA will lift the level of scrutiny that sex discrimination cases get above what this draft Dobbs opinion enumerates, which is, a crummy level of scrutiny. And so the ERA would overrule Dobbs in a way. So that has to be part of our messaging as well. I'll stop there.
Great, thank you so much. And we do have quite a few hands. I want to go to Ellie, who's actually the first in line anyway, but who also was there for the 1978 extension, and maybe can give even some more background on that. So Ellie? Ellie, I think you're muted.
Sorry, I agree. I like Catherine's idea of making it a victory. But on this 1978, we worked it out before. A major part of the campaign was you only takes a majority vote. It doesn't take a 2/3 vote. In those days, it was a 2/3 to. We don't have to get 2/3 twice. We already got that once when we proposed it. And remember, that was 78 to 72. It was fresh in everybody's mind. You needed it once, but you didn't need it twice. And I think we should work it out before that this is a constitutional amendment and it only at this stage requires a majority vote. But in addition to that, what we're thinking is there is this ERA valid resolution 891 in the House. It's not been introduced in the Senate, but it seems to me that because this is only the time limit, we should also, maybe we add the language of the ballot in it. But if we could get a valid vote, that would be great. And because what we need now is a constitutional basis for women's rights. And I think people will hear it more than they would before. What I would like us to do is be emphasizing both, but somehow we get this ballot resolution 891 before the Senate also. It would only take a majority vote. And then, because I'm afraid that this damn other thing, that this lawsuit's going to go to the Supreme Court, the current lawsuit. And I think we will have a bad decision. If they declare it's valid, I think that would be the strongest thing we could do.
And speaking of that case, we do have Michelle Kalin with her hand up. Michelle, did you want to speak a little bit to that?
Sure. And I think, and I think also just about kind of localities and what we can expect moving forward once the decision comes out. I agree, now there could be a temptation to really tie the ERA directly with abortion because it is kind of the place to look constitutionally to protect that right if it's not in the 14th Amendment. But the concern with going that route would be really feeding into the kind of opposition's narrative that the ERA is everything related to abortion and there isn't more to it. So, that's just something we might want to be cognizant of. While at the same time recognizing that this is a time that there'll be renewed attention on the ERA. But I wanted to piggyback off the kind of localities point and where to look in terms of no longer looking to the Supreme Court to vindicate rights. Looking at states, on the one hand, if this is sent back to the states, we know that there are, at least 20 states that have trigger laws, and the moment this decision comes out, that means abortion is illegal in those states. Then there are a number of states that are likely going to pass laws that attempt and that already have laws or maybe strengthen their laws that protect abortion rights. But one thing we might want to think about is looking at localities, looking at individual kind of prosecutors and state AGs that, just as we have a federal election coming up, we're going to have state elections, and a lot of state AGs are going to be coming in. There are some states like Michigan, for example, that has a trigger law, but it has a progressive attorney general, a progressive governor. And so looking to try to seek to either overturn the trigger laws there or get them interpreted in a way that causes the least damage, discourage local prosecutors from actually prosecuting based on those laws. There's a lot to be done on a local level that we should just keep on our radar as the kind of law underneath us evolves.
Thank you so much, Michelle. We have quite a few hands up. I want to get through the questions, and then I know we have to move on briefly to the archivist as well, and then a more robust conversation around SCOTUS. So Donna.
Yeah, hi everybody. I just, only because of the conversation before, I was talking about messaging and really being cognizant of the messaging that's going out. Is someone going to be drafting, because this is really a serious issue, because so many people, we're all dealing with a lot of anger right now, and it takes a lot to restrain, what we've done already. We've tried to use restraint in our commenting, but is something going to be provided? Because there's so many organizations involved with this coalition that we can all use the same talking points messaging to make sure nothing goes off the rails here. I agree with Michelle that we have to resist the temptation to tie the ERA to abortion, because I think we're just eating right into their hands.
So Betty, I will call on you, but we're just going in, I promise we will get to you. So as a coalition, we do have, top line talking points that we can share. And I think maybe we have already put into the chat. And I will say that the coalition, supports abortion rights, but of course we have a coalition, so we have a umbrella. So our talking points are probably a little bit more middle of the road than some other talking points on either side. So we can share those and say, this is what we feel as such, but also recognizing that there are going to be people within our coalition who have different talking points, and that could be either people in our coalition who are, have talking points that are much stronger on the connection of the ERA and abortion, and some who do not, see that direct connection. So it's a little bit difficult because we have our talking points, but we also respect that, we are a very large coalition. And we want everyone, and that not everyone will be using our talking points.
And if we could just say that in the chat, we are posting our statements, and we're talking about abortion now, which we'll spend more time on, but just in terms of information, our statement, we have the Columbia Law Project statement that they put out with some very helpful longer examinations of the issue. We have Revival Justice, wonderful statement that we're put in the chat. Allison McKinney, thanks so much for that. And if anyone else has statements, talking points, etc., we are Coalition 261 organizations. We are happy, to promote all of those and to discuss all of those and we're meeting with all of our partners and internally and externally to decide next steps, but you'll be able to see already the range of points of view that we have in the coalition.
What name should we be looking for in the chat for the official talking points? There's so much chatter, I don't know who's who.
Look for Chrissy West. Chrissy West is our communications director.
Thanks.
Oh, okay, so Frida Cathcart is the next person with their hand up. Rita?
Thanks. Yeah, I didn't know if you saw my question in the chat, but I was just wondering, since Collins and Murkowski were upset with the Supreme Court justices, is there a chance that they could be recruited to pitch the filibuster? And it has been pitched recently for specific bills. I was just wondering if anybody was going to try that tact to see if we could get them to do that.
You know, I think that we could, I think that would, you know, we definitely could. I think that that's probably another conversation that we should have. But you know, I think
Yes, the Murkowski-Collins question is always another question, but thank you.
I think that could take up another, yeah.
Thank you.
So,
Thank you for raising that. Go ahead. The other question.
Yeah, so we have Allison McKinney. Tim has a hand up.
Hi, everyone. I have kind of a bit of a point, but really a question, mostly for Professors Norse and Frankie. It seems to me like, coming from a judicial realist perspective, my sense is that given this Dobbs opinion, it seems that it's not possible at all to rely on this court interpreting the ERA to apply strict scrutiny in a way that's helpful on reproductive rights. In other words, it seems they're going to reach the result that they want to reach on that. And I'm mindful that I think Riva Siegel even said at the Columbia Symposium recently that there wasn't precedent to go from sex equality in the Constitution to reproductive rights, although I know the normative argument that she and others make is really compelling. So if they were willing to trash the precedent of Roe and Casey, is there any hope possible that they're going to reason from an ERA to reproductive rights when it's not even certain for sure that they would necessarily apply strict scrutiny? I know that that's the broad expectation, but I don't think there's any guarantee of that. So I'd just be interested, Professor Norse and Professor Frankie, in what your take is.
Well, Professor Siegel did make an argument at our symposium, and she's written a lot on this, as you all know. She's the expert on how we don't need the ERA in order to get elevated scrutiny for reproductive rights cases as sex equality cases. She cites the Hibbs case and other cases that have come down since Geduldig, which was the original case where the court said that abortion-related discrimination or pregnancy-related discrimination, excuse me, is not sex discrimination. And she says, well, look, we read these cases since then, and actually the court's taken a different position, even though they've never overruled Geduldig. You know, it's smart lawyering. Whether this current court would be persuaded is a different question. But I think what's important for her, and I think should be for all of us, is to be able to think two thoughts at once, which is one is that we can protect pregnancy-related discrimination as sex discrimination with the current law we have and argue as creatively as we can to get there and insist on it, and that the ERA will get us there. So it's a belt and suspenders, I think, kind of argument. And I agree with Riva on that point as well. But I think it's important to recognize that the courts are not, and the Supreme Court in particular, are not the only audience for an ERA. Right. We're also hoping or expecting that the ERA would motivate state executives, you know, the federal executive, you know, government across the board to undertake an inventory of ways in which sex discrimination is baked into government policy, never mind the private sector, and undertake initiatives to eradicate it. So we'll have much more friendly audiences there in many, many jurisdictions than we will in the Supreme Court. So I don't think that our discussion should only focus on this crummy Supreme Court that we have right now. And we won't have this one forever, right? If we get the ERA in the Constitution, it's there forever. These dudes will leave and we'll get new dudes and hopefully some gals who will take a different perspective than this crummy group we have right now.
Great.
Linda,
Thank you.
Linda, did you want to?
Yes.
Has her hand up, yeah.
Just to follow up on that, I mean, and I think we need to be honest with ourselves to follow up on what Professor Franke said, that this court would not read the ERA to change this decision. And we know that because the draft itself cites the Geduldig decision that Professor Franke just mentioned, which is the decision from 1974 in which the court said that regulating a medical procedure that only one sex can undergo does not implicate the Constitution, even the Equal Protection Clause. So, I think this court is not going to take the ERA, even if it were to recognize the ERA, and say it changes the result on Dobbs. It's just not going to do that. But I agree completely that getting the ERA recognized, whether it is through litigation or better through the Senate, is going to provide us with ammunition. It will provide the Congress with more ammunition to legislate. It will provide a reason to engage state legislators. So my own view, and I completely understand the idea, let's not just codify Roe, but I actually think we need national legislation, both recognizing the ERA and protecting reproductive rights. And those two things can be tied together to the extent that this decision really illustrates why we need an ERA. I mean, if the Constitution is frozen in time in the 1800s or 1700s, then, I mean, that was a time when a whole lot of people in this country were not recognized to have any rights at all. And so under that theory, the only way to fix this is to amend the Constitution. So I think that the Dobbs draft decision, if that proves to be the decision in the end, will give us really important talking points that we can use to support both kinds of legislation. But I do think we need both. I don't think just recognizing the ERA will go far enough, at least not in the near term, until, as Professor Franke notes, the current Supreme Court really turns over.
Great, and I think we have a hand up from Victoria Norris to respond.
Yeah, I just want to say that I think that, I can accept that realist skepticism, but I think it will change the conversation and the legal arguments, and not only in the states, as Catherine noted, but also in the court. Why? Because I'm an expert in methodology, and because they can no longer say, if it were ratified, that the states haven't said anything. They can't use the states' rights argument. They also focus on text. Okay, so textualism was a philosophy built to destroy Roe. It has taken over the court. They are very focused on that. So if in fact there is new text, it will change. It will have to change some of they're as tied to that methodology as they are anything else. I mean, look at everything they're focused on tiny words these days. So I think it will change the arguments, even if it might not change the result. And I would love to see them dancing around it. And finally, because I've worked on violence for so long, I do think the ERA will allow the Congress to fill in enormous gaps that we still see after Me Too that are, disheartening. And so, even if abortion does not lead to strict scrutiny, there is a gift in this decision, and it's embracing Geduldig, which has been ridiculed by women and male constitutionalists for 30 years. And it also happens to be, I'll just make one final point, not consistent with the court's own decisions. I'm writing an op-ed on this, which is, I wrote a book on the first reproductive rights decision. Of course, it involved men. Skinner versus Oklahoma. It is the first case involving strict scrutiny, and men get strict scrutiny. They also have a fundamental right to procreate, but those things don't apply to women. The opposite applies in Geduldig. So that's all.
Thank you so much. We have Nicole's hand up and Betty's hand up. So Nicole, do you want to go ahead?
I'll wait for publication. Sorry, I should have taken my hand down.
Oh, you want to check? Okay. Betty?
Yes, thank you. I want to respond to the ERA and Roe, if I may. And that is that 26 states will use the ERA to protect reproductive rights, to protect the right to abortion. So that ship has sailed, it's going to happen. We have on this call very uniquely top attorneys arguing the law, and we have activists. I am an activist, I'm not an attorney. I'm a former lawmaker. I spent 6 years in a state institution. But it matters not at all whether or not we use the ERA. I mean, in the past, I want to connect Roe and ERA. In the past, we have been able to argue that the ERA, that Roe is settled law. Okay, Roe is no longer settled law. So we said for a while it was unsettled law and we want to protect reproductive rights. But now it's not even unsettled law, it's being removed. And I just have to say that we cannot say it loud enough that the Equal Rights Amendment will protect our bodily autonomy. It will give us the opportunity to argue it. And I think that, as I say, the cat is out of the bag. We can't pretend any longer. We've been saying for such a long time, it's okay because Roe was argued on a different part of the law than the Equal Rights Amendment. But right now, everything is interconnected, and we need to be loud and clear, and we need to bring more coalitions in with us on this. That's my statement.
Great.
Betty Berry. Thank you for that, Betty. I think we are going to return to SCOTUS, but we wanted to spend maybe 10 minutes for the Archivist and publication. So I know it feels like a huge shift, but we did promise, and Nicole's hand was up for publication, so I don't want to skip that for the people who are on here and wanted to touch on that. So we are, as everyone is, I'm sure, aware by now, the David Ferriero, I'm pretty sure that's how he says his name, retired at the end of last week. His parting gift was to give a terrible interview, basically saying that, you know, Justice Ginsburg is the person who made it so that he can't publish. And now we have an interim archivist, and we will have this interim archivist until a new archivist is confirmed through the Senate. At the coalition, we are, you know, of course, still supportive of all efforts to see the ERA published. Again, this is, you know, a very difficult discussion, I think, or, you know, like, what does that mean legally? Will they do it because of the litigation and all of that? But from a public perception strategy, you know, having that would change the way the public looks at our argument that the ERA is already the 28th Amendment. And we also feel like it's harder to take something out of the Constitution and put it in the Constitution. So, you know, so something that we extremely are supportive of and have asked for a meeting, are asking for a meeting with the new interim archivist to speak with them, as we did in the past, but wanted to, you know, open up for people's ideas, thoughts on the retirement, thoughts on moving forward. And Nicole, glad to start with your question. Nicole, I think you're.
Sorry about that. So I guess from Shannon Glass's perspective, that publication has been the key to kind of saving this issue for quite some time. And we've been working on it. And as that relates to the resolution, what I've seen in like the past week and the way people have shifted towards rhetoric, I would say people we had support from before, it is almost appearing as if we're being, it's political, that they're playing politics right now with these issues in terms of gender equality and that being the strategy for the midterms. So we signed the letter on in support of the resolution. I just do you have the sense of whether or not we're still getting the same message from the Hill? Because I'm not really getting the same message in the past few days.
So what's the message that, I'm sorry, can you just explain to me what message you're talking about?
I'm saying in the past, we had some strong support for publication, widespread throughout Senate Democrats. That then got kind of quelled by Senator Cardin saying SJ Res 1 had to be the focus. So we lost support there from some people. The senators are fully aware, and as is the White House, of the link between Roe and publication, but yet none of them are speaking of it right now and are trying to come up with ideas. It just seems somewhat disingenuous right now, the way they are moving forward.
So I have spoken with various offices in the Senate. I don't think that I think that there are two different discussions here. You know, one is, are the senators supportive of publication? I think that's easy to say yes to, right? Two is, what is their role in publication? And I think that that's where they're saying, we don't know what our role is, right? So they don't, except for there have been conversations around whether or not they feel that they will use the ERA as kind of a litmus test for whoever the next archivist is confirmed. But in terms of, you know, whether or not they send a letter, their letter, you know, doesn't necessarily have that much weight. Like they cannot vote for the archivist to publish the ERA. And so they're trying to say, what can we vote for that will move this issue forward? Like, what can we take action on? And that's why they're focusing on SJ Res 1. And, you know, I've heard some concerns about, you know, interfering with the rule of law, them, you know, messing with the law case and the Department of Justice and all of that. You know, that is just what it is. But I don't think that I don't think Senator Cardin, Senator anyone would say, we don't think the ERA should be published by the archivist. I think that what they're saying is, where is our effort most useful to seeing the Equal Rights Amendment in the Constitution? So, I mean, you know, they can write a letter, but that letter, the only thing that it could potentially do is say, put pressure on the archivist, and maybe the archivist will listen. The past archivist didn't listen to anyone, you know, and so I think that there's a difference between like how they feel about publication and how they feel about where their efforts are best put.
Yeah. Any of the experts in the House want to weigh in on that? Victoria, Catherine, Linda?
I think the debate in the Senate would be about, you know, their constitutional role, and no one knows the answer to that, and it would get a whole bunch of people off topic. The Cardin bill is much simpler for lots of people to vote for, and you might get more than, you know, it will be bipartisan. It would be unprecedented. I mean, Congress could enact a statute that says, you know, Mr. Archivist, publish the amendment. They certainly have the power to do that. You're going to get more people opposed to that on constitutional grounds. They're made up, but they make up the Constitution all the time. Cruz and Lee do. So I think it would distract from the issue, which is women's equality. It would get into all sorts of arcane institutional matters about an archivist personally, when we want to keep the focus. And I understand people worried about politics, but you can't get rid of that. It's in the Constitution that they're elected from small geographies, and they're going to have to respond to those people. One of the great things about Dobbs is there is a lot more activity. You know, my daughter and all these young women are terrified, and they should be. And I think that we need to focus on the issue and not the archivist as much. But that's just my personal view of where the debate would go in the Senate on such a thing. I think validity would be great if you could get validity. I know Ellie has suggested that if you could get that, I'm not so sure you're going to get that because of the Ruth Bader Ginsburg quote.
Oh, come on.
Yeah. Catherine, any word?
Well, I have long thought that the archivist was a non-issue. I would not have prioritized it as an organizing issue, but I know others disagree. But I do think that if you want to focus on the archivist, you ought to wait until the deadline is lifted, and then archivist action will actually be easier to defend in court than where we are right now, which is in a pretty vulnerable place if we could get the archivist to publish. So in terms of staging political energy and organizing, I would focus more on the deadline bill than I would on the archivist at this point.
And Linda? Sure.
Oh, I totally agree with that and have nothing to add. I think the single best thing we could do is to push for SJ Res 1. I think that is the single best thing we could do. It is the closest thing to kind of ordinary, the way this is supposed to work. And that puts us in the strongest position to defend the ERA in court.
Great, thank you. And I see Bobby and Judy have their hands up.
Okay, for me to go, Judy?
Yep. I just still doing it, Bobby.
With apologies, I did not realize until I just got on about 6 or 7 minutes ago that it was today and not on the 12th. And I'm just sorry I missed the conversation. And I also don't know if Linda happened to mention anything. I had emailed her yesterday with a question that I think, I'm just going to say, to me, the best defense is a good offense. And I think that what I've heard now is absolutely right. We should, I believe, act completely on the premise that it's in the Constitution. It's effective as of January 27th of this year. And that we should even shift the conversation to a couple new things. And one new thing I posed to Linda that she was going to be looking into was, just occurred to me that if in fact the ERA is, as we will contend because we believe it, effective as of this past January, what is the legal status of any judicial decision since January 27th of this year, if it was made without considering equality of rights under the law should not be denied or abridged? And if in fact, as I can understand, they may well not consider that, what's the status of any decision when in fact the ERA is affirmed, published, certified, and acknowledged to have been effective by January 27th of this year? It's an absolutely unprecedented legal kind of quandary, but I think we should ponder whether that's a point. I'm not saying this is our whole initiative by any means. Is that a point we want to explore a little more and start contending, wait a minute, courts should not be bleeping, making any decisions until this has been taken care of. And I added to Linda, I think I heard that no courts are going to be deciding on any of these, fill in the expletive, undeleted blank, these decisions about 6 weeks for abortions, et cetera, that the courts are not going to be deciding on any of those until Dobbs comes down. Well, if they can push pause for that, they can damn well push pause for until the ERA is settled. So I'm a little upset, as you can tell, as we all are right now.
Just a little, Bobby.
Yes.
But would love to throw that to our legal minds on that question of what does this mean now that decisions are being made post January 27th, but the equality of rights under the law shall not, everyone knows the text,
yes,
is not being applied.
So I can respond, Bobby, just from the perspective of how lawsuits work. So lawsuits are decided based on arguments made by the parties before them. And so if parties in litigation are not arguing that the ERA is valid today, then the court can go ahead and decide that issue, and there would be no reason or occasion for the court to delay its consideration of that issue.
see that point.
I mean, it's just the cases are decided based on arguments that the parties make in their briefs. And, you know, in the Dobbs case, for example, the argument was not made that the ERA is effective and would have some kind of impact. Now, if the ERA is recognized, and particularly if the ERA, like for example, if SJ Res 1 passes, and the result is that the ERA is deemed effective as of the ratification by Virginia, then I think you could argue in a later case, well, don't pay attention to that decision that was rendered because the court didn't have the opportunity to consider the impact of the ERA. The decision wouldn't go away, but the people who are litigating in future cases would be able to say, don't pay attention to that old decision. That old decision didn't consider the ERA. So does that help? I mean, it's not really possible to stop the consideration of any existing cases based on the ERA if the people in those cases weren't arguing the ERA, and odds are they weren't. And I'm frankly, I don't even think that's particularly a bad thing. I mean, we need a decision recognizing that the ERA is valid, and ideally we will first have an action by the Senate, which will increase the odds that we get a court to recognize the ERA as valid. And then people will begin to use the ERA in litigation. Or if SJ Res 1 passes, people can begin to use the ERA in litigation and make the arguments, and courts will have to decide in those cases whether SJ Res 1 really is effective to remove a time limit and makes the ERA part of the Constitution. So if SJ Res 1 passes, I mean, my argument in litigation would be that the ERA is effective all the way back to when it was ratified by Virginia. Eileen asked the question, is it retroactive? I think if it became part, yes, I think the answer would be, it would be retroactive. That wouldn't upset or remove or blow up any decisions that have made since then. But you could argue in a future case that the court shouldn't pay attention to those decisions because it didn't have the ERA before it.
Catherine, that's why we're paying you the big bucks. Thank you. That was very good.
Thank you.
Catherine would love to hear
the pro bono big bucks.
That's right. That's what I meant. But thank you. Could I just respond real quickly? Absolutely. That was extremely, I'm sure, accurate and lucid and understandable. Is it, though, something we could consider from right now, putting out there the question of, look, is this casting into doubt or for future reference, weakening decisions that are being made as of January 27th? I think that could be a point we could sharpen and get out there, and perhaps particularly get to people who might be litigating just now to have them consider, if it makes sense, in their briefs, putting in the fact that the Equal Rights Amendment, it's very plausible that that is in effect, and start arguing on the basis of it.
Yeah, Catherine, you have some experience in this, yes?
You mean I was alive when the 14th Amendment was pending?
I want to hear what you have to say on this subject.
No, I think Linda covered it quite well. But I mean, just know that when they lift the debt, let's say not if, but when they lift the deadline, the fight's not over, right? Then we have to deal with the states that want to withdraw. And personally, I think that that's actually a pretty strong argument that that if states have the right to ratify, they may also have the right not to ratify. And that may be a pretty tough argument for us to defeat if we want to say that this ratchet only goes in one direction and not the other. So, we got to think about which fights we're ready to have and be ready for them the moment we lift this deadline, that the 5, or then there'll be more states that have withdrawn their ratification, will start banging that drum. And so in terms of legal fights I want to take on right now, the sort of the shadow of the ERA being cast over current litigation seems to me to be not as urgent to me as the states that want to pull their ratification.
Yeah, and to be clear, the case that is currently pending in the DC Circuit, that's probably the best posture we could hope for to litigate the issue of the deadline right now. I mean, I personally think, and I think a lot of people think, we would be better off litigating this issue after action by the Senate. And if if it had been possible for us to delay litigation until after passage by the Senate, that would have been my preference. It wasn't really possible. Like the litigation train was out of the station. So we did our best, I think, with really with Michelle and really excellent people in the Attorney General's office to position this case that we have in the DC Circuit in the best possible way, given the facts as they are today. So I want to see that case through, at least through the DC Circuit, and see what happens with it. But I think beyond that, our attention really needs to be on the Senate rather than on the courts at this moment. We will be much better off in any litigation if we have an action by the Senate first.
Great. I see Judy Lotus's hand has been up.
Thank you.
Judy, you're muted, so.
That. There's an old adage in advertising which says, don't give me no recipe, just bring me the cake. And I think that's what we need to be thinking about. There's not one person on this call who is in the Constitution. And if any of you on this call is lucky enough to be pregnant, chances are you're stuck with it. These are such basic emotional things. And what I would like to see all of us do is arrange a day or 2 days or more for women to go on strike and just bring some dramatic attention to this, because we talk and talk and nobody listens. I'm tired of writing letters that get form letters returned. I think we need a bold, dramatic action. Thanks.
Yeah, and we're
Thank you,
getting the feedback of that as well from everywhere, that people are ready. And someone put in the chat that there is a march on May 14th on that Saturday being organized, the first, I guess, of many bigger things that will be happening. And we're talking to all of our colleagues about how we get the information for all of that to, to our partners. But the whole idea of the lockdown becomes more and more appealing. Everything, Judy, except for ordering from Amazon. I'm not sure that I would be able to.
That would really hurt. We could stop the economy.
It really hurt, but it's worth it.
Do it. But I would do it, but yes, we need to think about something really, really big and to say, come on, this is just, this leaked brief was just so mean and so inconsiderate, frankly, an assault on women's rights, that there's really no way of, of getting around that or tolerating it, quite frankly. So I personally am all for that. As a coalition, we'll decide how we move forward on that. But I guess, Catherine, Frankie, you have developed talking points and an argument for us on the ERA and abortion, and I would love to hear your thoughts on that at this point.
I believe Catherine just had to hop off, but if
Okay.
Ting Ting or
Ting Ting, are you still there? Sorry about that, Catherine.
if Ting Ting or Candace are on, she said they can serve in her stead.
And one of the things that we'll say while we're getting Ting Ting up, we did put it in the chat so that the Columbia Law Project's statement, their complete argument is in the chat. One of the things that we have too is that one of our advisory council members, who's a filmmaker, has made a documentary that our board member, Alyssa Milano, is hosting on the history of abortion. And it is an educational piece, not a, piece of any, political persuasion. It's an educational history of abortion in this country. And it went up on Now This morning. So we will have that. It should be in the chat, and it's available to all of our partners to use as an educational piece should you need it, or want it. So any other thoughts about Ting Ting, are you there? Or did we lose the whole Columbia? contingent.
I'm here.
Hi.
I'm here. Hi. I'm traveling. I'm checking into a hotel. Hi everyone.
Oh, very good. Ting Ting has always been good about that, you know. It's
just on the move. Yeah.
On the move.
Yes. We have we released a press release, and then we have these concise talking points on sort of the equality arguments to the right to abortion and the relationship to the ERA. And then, as you all know, we submitted an amicus brief to Pennsylvania challenging their public funding of abortion using the state level ERA. So we have a lot of materials to share out with people. And, you know, like what everyone, all the brilliant minds have covered on this call, a lot of this stuff is literally laying down that kind of long-term groundwork that the right is so good at doing, right? And to sort of do the work of, like, of course, we're all reacting. A lot of this is like reactionary, but also doing that kind of like long-term groundwork of building the equality arguments into something that could protect reproductive rights. Because when it's about privacy, it's about your rights that flow out of the body. But when it's about equality, it's about sort of what the infrastructure is that we're all living in that prevents us from accessing basic equality that get triggered when we have medical issues or reproductive rights issues or all of these concerns. It's much bigger. It's about kind of like putting the onus on the environment and the government. So I'd say that shift from privacy to equality is also really meaningful and crystallizes why the ERA is, you know, one of the most important things that we need to focus on right now for women and sexual minorities.
Great. Thank you, Ting Ting. That's what I was trying to tease Catherine into talking about Pennsylvania. But thank you for that work.
I have a question on that though. If there's a worry about how this court would be interpreting the ERA, you know, if the Pennsylvania case were to get to the Supreme Court, are you worried about what the decision would be and how that would set precedents?
Well, the Pennsylvania case, it's in the Pennsylvania Supreme Court, so it'll end there. But I mean, the existing rule is that the state Medicaid, it does not fund abortion. And so the worst thing that can happen is nothing changes. Or if they decide to overrule their previous precedent, which follows that Geduldig model of pregnancy related discrimination is not sex discrimination, right? They could overrule that. And then that would, you know, provide abortion and medical access to pregnant people in the state, which would be amazing.
But there's no, but it won't go to the Supreme Court.
No.
Is what you said. Okay.
Yeah,
That
it's
is
just state level.
Thank you, Ting Ting.
Are the hands still up, Michelle? Or is your hand still up? Eileen? Michelle?
Yes, hello. Oh, Michelle, go ahead.
You go, Eileen.
Okay. Well, no, let you go first, Michelle.
I just wanted to say about the overlap between the ERA and Justice Alito's opinion, assuming it is published the way that it's currently drafted. It's worth keeping in mind that there's a part that talks about how pregnancy discrimination is not sex discrimination. And so to the extent we're going to be formulating arguments that arise related to that opinion, and we want to talk about abortion and its relationship to the Equal Rights Amendment, we'll have to contend with Supreme Court language saying that pregnancy discrimination is not sex discrimination.
Yeah, and that will absolutely be like a complete turning of the tide. So that's like a really important point that Michelle is making. I point people who are interested in these kinds of arguments to this amicus brief that Riva Siegel authored with Melissa Murray and Serena Maori, these amazing common law scholars, in the Dobbs case, where they lay out the equality arguments for abortion, and then also how to relate that back to the fact that pregnancy discrimination is sex discrimination versus the Supreme Court's very narrow and incomprehensible holding of it not being that.
Can you post that link in the chat, please, for everybody?
Yeah, you know what? I can find the PDF and I'll just put it in the chat. How about that?
Or put it in the email that follows up, Tina?
Yeah, I'll send it to you, Bettina.
Okay.
That'd be
All right.
perfect. Thank you.
Is
And
it
it
my
looks like
turn? Is
Is
I
there
never,
possible, can we just let Victoria Norris
ahead.
just respond? Yeah.
Sure. Okay,
I
I'll
just
wait.
want to say yes to what Ting Ting just said. It's very important. Most women think that you can't, if the state fires you because you're pregnant, they can't do that. Well, the only reason that's not constitutionally protected, it's by statute. Okay, so the Supreme Court in Geduldig made this ridiculous claim. I mean, it's easy to ridicule about, well, who are these pregnant persons if they're not women, right? So I want to make sure that people understand that it's there's a lot more at stake. We've never, and several people have mentioned this, we are not in the Constitution. So to maintain that, use the momentum of Dobbs, because Dobbs is not simply about abortion. It actually elevates Geduldig, which is one of the worst decisions and something no one really thinks is correct, right? So these guys would take us even further back, right? If Congress or the state legislatures didn't do something. And that's an important point to make as you argue for the ERA. And people don't remember this because it was so long ago. Women think they're protected by things, and it's not the Constitution. It's various statutes that Congress has passed or that the states have passed.
And in the context of then Congress stepping in to correct maybe a problem with the Supreme Court holding, in the context of pregnancy discrimination, that Pregnancy Discrimination Act also sucks. That's another example of where the Supreme Court did something horrendous. Congress said, oh, we have to fix this immediately. So we have to amend the Civil Rights Act to sort of say pregnancy discrimination is a form of sex discrimination. But the way that that's been interpreted by, surprise, the Supreme Court has been so limited that that protection has no legs at all. Plus, it doesn't apply to employers who employ people who have businesses with less than 15 people. So you can imagine all sorts of workers, pregnant workers who are kept out of that very measly protection to begin with. So, that's why we need an ERA. We need something to kind of push the conversation forward and to empower Congress in a new way.
Great.
My turn?
I think that's all really helpful. And yes, it is your turn, Eileen.
Okay, well, I'm gonna have to double my blood pressure medicine because I'm so pissed off at this point. Now, one of the things I wanted to point out is a couple of things. When Alito wrote in the brief that the abortion is not, the word abortion does not include, is not in the Constitution, I was screaming, neither is the word women. Neither is the word women. And then I wanted to go back to what Ting Ting said about, and I think it was Victoria, said about women remembering. I've been getting phone calls, I've been getting slammed with phone calls from women who were adults in 1973, and they want to start some kind of advocacy trend called We Remember, to remind all the young women who think they have no idea what is about to hit them. And even Republican women who they're like the dog that caught the car and now they don't know what to do with it. And so We Remember, with in terms of just like, do you have any idea what's coming? Do you have any idea what's coming? So I'm going to put that out there to all the women that are of my age or older, that this may be a narrative. And on the other hand, I want to talk about the idea of the same thing with medical professionals.
I'm thinking that
medical professionals, we've all had that patient, all of us. My medical professionals are freaking out.
So that you should really catch up on some of the work you do, and then you'll go to Kathy this afternoon.
Okay.
Yeah, but I want you not be on your screen doing things.
Oh,
thanks.
And the other one is, as a medical professional, I have to speak on behalf of my medical professional friends. Anybody who's ever worked in the ER and in primary care like me, we all have those horrible stories. So when they say it's one-offs about 11-year-olds and all of these crises in the ER of women, the idea of having to go and delay care while you go and get some permission from a gynetician, the medical community is freaking out about this. And so that's another area that I think that we have to really start looking at, is all of those personal stories of, in terms of reminding people, academically, everybody thinks they know what it means, but I think we have to go back to the actual, do you really understand what is about to happen? So I'm just going to throw that out and leave it to this group, this beautiful, brain trust to come up with ideas on how to get out. Because when my work in the General Assembly has always showed me that personal stories do carry weight. And I think we have to look at the medical professionals that are freaked out about how are we going to respond to an ER? What is our liability? Are we going to go to jail if we do our jobs? You know, and also the whole idea of those of us who are of a certain age who do remember all of this. And how do we tell the young people, you might want to press the pause button on this? So I'll stop there.
Thank you, Eileen. We have Ellie has her hand up. Oh, Ellie, you're on mute.
This coalition has taken a stand that the ERA is valid, and we have been supporting 891. I do not understand why we should not also support it on the Senate side. I mean, because we shouldn't give up that position. We really do believe that the requirements have been met. And the only two requirements of the Constitution. And I also think that whether we like it or not, we really have to be honest that, yes, I believe anyway, that the ERA, if we had a Supreme Court that was not ideologically opposed to us on everything, but anyway, that the ERA will give some protection, some constitutional basis to abortion. I mean, there is a reality that they have destroyed if in fact this brief is the brief, they have destroyed the concept of the right to privacy. Every time we have spoken on this subject before Congress, I'm talking about leaders of this movement, we have clearly said that we want it to cover the abortion, but it isn't needed because of Roe. In other words, we might not have said it in those words, but of course we hoped that it would extend more rights to women, including reproductive rights. But we were grateful that we had already the principle of the right to privacy. If they're going to destroy that principle, then we for sure need the Equal Rights Amendment, because it gives you something. And as far as pregnancy discrimination, the women's movement pushed for the Pregnancy Discrimination Act of 1978. And yes, it is not perfect, but it has resulted in billions of dollars of settlements for working women every year. And thank God we got it passed. I mean, I really think that, but I don't think we have this wiggle room. We've all said that it is valid. We now have 174 co-sponsors. I think we can pass it in the House if they put that. And I think that with this emergency, it's a time to explain exactly what gains we would have if we had the RA for reproductive health. And so I don't know, my whole feeling is that we shouldn't back off. This is the first time that we've had so much attention in a long time. And we need much more protection in the Constitution. We need the Equal Rights Amendment. And I think people will listen to that and accept it more now.
Great, thank you so much, Ellie. Nicole?
Okay, thank you. This is a question for Professor Norse. I think I heard you say before that if we could somehow get validation, whether through publication or through the resolution that Ellie was referring to, that could change the opinion in terms of the standard that would apply. Was that an appropriate summary?
Okay, if you could, and let me just clarify for, I'm going to have to get off in about 10 minutes, but for Ellie, I think you have to get to Schumer and you have to tell him you want it all.
That's it. That's
all right. And let him figure out procedurally and politically how that's going to work. All right. He controls this with the parliamentarian. And I think that way you will at least get a bipartisan vote extending the date or fixing the date. That's the least you will get. But if you don't ask for everything, you'll never get it. So you got to ask for it. Now, having said that, and actually prioritize that over, in my opinion, the statute on abortion. That would be my order. They might want to put that in there because it's a harder vote, but ask for it all. Second, but you got to get him, because there are ways he can structure this, depending on the difficulty of the vote for individuals, that could make it even more bipartisan than we have it now. And the more bipartisan, the better. So add in validity. Two, if the Congress, both houses pass validity, Joe will sign it. Okay. He has no reason not to sign it. If that happens, people will litigate that and whether it was valid. This court, I don't know. I think that the better argument would be that they should stay out of it. Their whole theory in Dobbs is to stay out of politics. Well, they should stay out of deciding on the validity of a constitutional amendment. All right. It's called the political question doctrine. Several people have already filed briefs on this. So there's a good argument. You might get 5 votes for that. Would this come up if you got validity? Would you be able to challenge abortion? Would you be able to challenge anti-abortion laws in the states under the Equal Rights Amendment that is now valid? Of course you would. What the court would do? I don't know. I mean, their theory says they honor text. Their practice is they hate women. So, I mean, I shouldn't say that. I mean, that's a little expressive. But they don't get it. And I'm writing a book. This is much bigger. I mean, we've assumed things are protected that just aren't. And it's much bigger to me than abortion. And for a lot of those who have been working in this area, we might have focused on that, and it will give you a lot of political power. As Ellie said, this is the time to strike now while people are mad as you know what. And young girls are crying and upset, and their parents are hearing about it. Their Catholic parents are hearing about it. And so, it would allow, if it was valid, it would allow you to go back and redo Dobbs in a different case where you would challenge a law and say, no, that violates, you can't do Dobbs anymore. There is a text in the Constitution that you must now honor. Now, they could, as somebody said on the call, manipulate it in some way. But I think there would be much stronger, they can't go back to Geduldig. You would have definitely overturned Geduldig, which is one of the reasons why the court is only looking at this as a right of privacy under Dobbs. And they said equality doesn't apply because of this Geduldig decision. Now, as I said, I think that's wrong. This opinion, by the way, if it comes out, is going to look different. That's dated February 22nd. That was circulating to the justices, and they are going to change various things in it. So that dismissal, the Geduldig part is actually, I think, legally incorrect, given this other case that no one's ever heard of, Skinner versus Oklahoma. However, just saying, yes, you would be able to challenge a state law if it were valid.
Thank you so much. And Carol has her hand up. Carol.
Yes, thank you. I've been wanting to ask this question since we started, but I was waiting for the right time. And I see there's things in the chat that are going to relate to what I was going to ask about. SCOTUS isn't like Congress where you can pick up the phone and call or, write a letter or, knock on the door. So I'm wondering, it's a 2-part question. One, what can you do with the Supreme Court to get to them, to let them know how we feel, other than, the media? And 2, if we can, and I'm seeing some of this in the chat, if we can have women write letters talking about their experiences, can we send them to the Supreme Court and have them look at them? So it's a 2-part question, if anybody can answer it.
You can always write the court a letter, whether they listen to them or not is another question.
Right, but would it be effective, in other words, if we had a lot of letters? And we got to do something to stop it before it happens.
Yeah, all of us are wishing that a letter or 1,000 or 10,000 letters would make a difference, but I'm not so sure. It was one of those, as I was talking with the staff this morning, it was like a pure Wizard of Oz moment, where the screen that drapery was pulled back, and there you saw, these mean little, mostly men, deciding the fate of, of the entire country. It was just, so that their cover has been blown, in terms of
If
of
I
who
may,
they
Carol,
actually are.
if I may, Carol, the best comment was Stephen Colbert's, who said, "This decision was made by 4 old men and a woman who thinks The Handmaid's Tale is a rom-com."
Right.
Right. So it's, so.
There's got to be something. That's what
And
I'm
he's
just
a Catholic, and he's a
Yeah.
Catholic.
Yeah, there's got to be something we can do, I guess is what my question is. What can we do?
Get Congress, the first step to do this is to really push on, make it as visible as possible. How did we get the right to vote? People, chained themselves to the White House.
Right.
I mean, I wouldn't do that to Joe, but fire. However, I think the more, that people hear it, it's not going to change the court. They believe this in they have what I call the righteous mind. They believe that they are Brown versus Board of Education overruling Plessy. They believe that they are getting out of politics. The only thing that might change this, if they really thought this was, because frankly, this is a gift to the Democratic Party, in my opinion. It is a big gift. And for those of you who think it's about politics in a bad sense, this whole thing is, they gave, abortion has been a gift to the Republican Party for a very long time because it has harnessed their most extreme righteous minds of people who really cannot see the other side. And so I think that it's not bad that it has a political, because political is not just about being partisan, it's about voicing what we should be doing. And now you got to get out and vote. I mean, vote like your life depends upon it. Like Michelle Obama said, just keep saying that to every young woman you see. When we had the ERA and Alyssa Millan was there, I went up, and I'm usually a pretty shy, nerdy kind of gal. And I said, ladies and gentlemen, there's a new court in town. I teach this. I know this for 20 years. And they believe it. They're not going to be changed by anything you do, in my opinion. But the way you can fight them is elect people to the House and the Senate who will help you with the Equal Rights Amendment. It can be done.
I hope you're right.
Which is a cue for our elect equality, that we, used in the last election, and that we're doing again, rating every single person running in the House and the Senate, and trying to get a way to get that all the way down, on the city, state, the village level, so we'll be sending that out. We're staffed up now. So, we're ready to get that ERA certified out to all people running for office, wherever they may be. And our line is that if they're not certified, if they don't support you, you can't cast a vote for them. So, so that's and yesterday we were on the emergency call that NARAL had. As soon as that call ended, hundreds of people who were on that call started phone banking. And so I think that's the key. We've got to it's the election, folks, it's got to get moving on all of that. And we'll have, more details about, elect equality and, and our plans with our partners in terms of marches. And, the other day, the first day of this, as I posted on Facebook, I ate an entire box of chocolates and was on Amazon looking for a gas mask to figure out which one I'm going to use for when we have protests. I have to get the whole staff gas mask.
All right, ladies, I've got to go.
Thank you so much. Thank you. I know we went over too. Thank you.
Your work is the most important, not the legal. Go out and elect some great women. Okay. Bye.
Thank you so much.
Thank you, everybody. Unless anybody has anything else to say, we'll see you next Thursday.
Bye.
Okay. Thank you, everyone.
Great.